Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast. I'm your host, Spencer Karen. On November 3rd, 2020, the Supreme Court heard oral argument in Borden v. United States. The question before the court was whether the use of force clause in the Armed Career Criminal Act encompasses crimes with a mens rea of mere recklessness. Joining us to discuss this case's oral arguments is Kent Scheidegger. Mr. Scheidegger is the Legal Director General Counsel at the Criminal Justice Legal Foundation.
Thank you. In Borden versus United States, the Supreme Court once again explores which prior convictions count for the purpose of the Armed Career Criminal Act. That act adds an enhanced penalty for illegal possession of a firearm by a convicted felon if the felon has 3 priors for violent felonies. However, defining violent felony, given the wide range of state laws, has proved difficult. Justice Alito noted somewhat sarcastically during the argument, "It's always a pleasure to have another case involving the Armed Career Criminal Act." The provision in question in this case includes, as violent felonies, one which has as an element the use, attempted use, or threatened use of physical force against the person of another. The question is what mental element the state law has to have for that provision to apply. There are 2 main precedents involved. In Leocal versus Ashcroft in 2004, the court held that accidentally injuring a person while driving drunk is not a violent crime under another statute with the same wording. The court did not resolve whether recklessness would qualify under the statute. In Voisin versus United States in 2016, the court held the definition of misdemeanor crime of domestic violence in another provision of the Armed Career Criminal Act does include recklessly committed assault. The definition in that provision is use of physical force by persons with specified relationships to the victim, but there is no against phrase in that statute. The Model Penal Code establishes a hierarchy of mental states: purposeful, knowing, reckless, or negligent. This structure has been widely adopted. The defendant's contention is that the against language in the Armed Career Criminal Act draws the line between knowing and reckless, while the government contends it is between reckless and negligent. Justice Roberts led off with the kind of hypothetical we typically see in these cases. He asked about a prankster who swings a bat near someone, not intending to hit him, but the bat slips and does hit him. Wouldn't this reckless conduct be naturally described as the use of force against the other person? Defense counsel says it would not, and he continues to insist that use of force against a person is only intentional or purposeful or knowing use. Justice Breyer noted that under the Model Penal Code's strict definition of recklessness, it is limited to conscious disregard of a substantial and unjustifiable risk. He suggests that there is little difference between that and knowing that the result is likely to follow. And indeed, the Model Penal Code does group recklessness along with purpose and knowledge as the mental states that are included by default in every statute that does not specify a mental state. My own brief in this case presented some research that shows that most people, given a set of hypothetical situations, do find reckless conduct comparably culpable with knowing conduct and really can't distinguish between the two very well at all. The defense counsel made various responses to Justice Breyer's comment, but perhaps the most convincing of these is that many states do not define recklessness as strictly as the Model Penal Code does, and the distinction between recklessness and negligence is often thin. At the other end of the scale, Justice Alito asked him about second-degree murder. which in most states has a variant of recklessness, so-called depraved heart murder, as the way you can commit murder. If you do something extremely reckless, such as shooting into an occupied building and kill somebody, that's murder, even if you didn't intend to kill anybody. Under the defendant's definition, would a convicted felon with 3 priors of second-degree murder not be classified as a violent felon? Defense counsel hedged that perhaps the extreme recklessness required in depraved heart murder might qualify, but still said the better view is that it would not. That supposedly better view might sink his case, because it would strike most people as absurd that murder is not a violent felony, or that a murderer has not used force against the victim. Justice Sotomayor asked about the wide range of mental states that qualify as reckless in various state statutes, and this really gets to the most difficult part of the case. Excluding all reckless offenses would exclude some that obviously are violent, like second-degree murder, while including all reckless offenses would include some that most people would not consider violent. Justice Kagan asked about a pair of hypotheticals about a bank robber who hits a person with his car in making his getaway, one where he does so knowingly and the other where he does so recklessly. She saw little difference in moral culpability between them. Justice Gorsuch asked a remarkable question about construing the statute even more narrowly than the defendant asked. He asked if it should be construed to be limited to intentional crimes, by which he apparently meant what the model penal code calls purposeful crimes, crimes committed with the actual purpose of producing the bad result, and excluding those committing knowingly but not purposefully. It seems unlikely that any of the other justices would go along with this, but perhaps he is taking out a unique position. Justice Kavanaugh suggested that the simple solution, which is often the best one, he says, is to simply take Leo, Cal, and Voisin together as drawing the line between negligence and recklessness for all of the statutes defining violence in terms of use of force. Defense counsel continued to insist that the difference in language in the 2 statutes precludes that approach. During the government's argument, Justice Kavanaugh noted that the court in Voisin had stated that this was where Leo Cal had drawn the line. Justice Barrett asked 2 questions that appeared to be skeptical of the defense position. She noted that many state statutes define assault as including recklessness. Given the court's categorical approach to state statutes, the defense position would exclude all assaults in some states, even though most people regard assault as one of the quintessentially violent crimes. Second, she referred back to Justice Kagan's car hypothetical and did not think that considering the reckless use of force in that example as being against the victim was at all a stretch of the language. The attorney for the government, on the other hand, was asked about situations where state courts have found recklessness for nonviolent conduct, particularly with regard to driving cars. Such things as driving while texting and failure to buckle up a child have been found reckless, but few people would consider these to be acts of violence. Justice Breyer noted the consequences involved as a reason for narrowly construing the statute. This statute imposes a mandatory minimum, while even without the mandatory minimum, the judge can still impose up to 10 years in prison in an appropriate case. Justice Sotomayor also noted this consideration. Justice Kavanaugh noted the countervailing consideration that the statute requires 3 prior felony convictions. In Borden's case, he has 2 priors for intentional assault, which are unquestionably violent crimes, and only the 3rd conviction is in question. Unlike the statute in Voisin, which takes away the right to possess a gun based on a single misdemeanor conviction, this statute is extremely unlikely to apply to anyone who is not, in fact, a violent criminal. I won't pretend to predict the result based on the oral argument. That's always a very dicey thing to do. I think we may see some crossing of the simplistic liberal-conservative lines here. It looks like Justice Gorsuch is more friendly to the defense position than Justice Kagan is. So we might see one of those scrambled cases. But we'll wait and see. We will expect a decision sometime, maybe early spring, perhaps even later.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers. founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.